Today we're going to talk about the listing agreement or the authority to offer for sale. This is the Form 200, the OREA Form 200. Okay, so it comes in 3 pages, and at the very top of the first page, you're going to initial and indicate whether your property is to be listed on the MLS, which is the best way to market your property, or whether it's an exclusive agreement. Sometimes there might be reasons to have an exclusive agreement if we're not quite ready to go live on the MLS, but we want to be ready to receive potential buyers in case they come by. Or it could be something personal that we want to wait and not put it on the MLS. The contract itself is between the brokerage and the seller, and both are indicated here. And then the amount of time that the property will be listed for. It'll give the start date and the end date. If the period of time is over 6 months, then the sellers will need to initial beside that, showing that they recognize that it's longer than a 6-month period. After that, we're going to indicate the listing price for the property. And then it goes into explaining definitions. And the first thing we're going to talk about is commission. So the commission is identified here, and it's going to give you the whole commission for listing the property. After that, it's going to talk about commission that is shared with a cooperating brokerage. So if the brokerage, our brokerage, is not the one to bring you the offer and it's another brokerage, then the amount that we've agreed to for the commission is going to be split and shared with the cooperating brokerage, and it will indicate the percentage there. It's not cumulative, it's part of the total commission. After that, the form talks about a holdover period. So normally we have a holdover period so that if we introduce a buyer to your property during the time of the agreement, but they make an offer within the amount of time indicated during the holdover period, that we're still protected by the contract and we respect the contract and ask for our commission because we've done our job and we've introduced the buyer to the property. After that, it talks about representation and multiple representation. So if we are representing both the buyer and the seller in the same transaction, it becomes a multiple representation situation. In these circumstances, we cannot indicate your bottom dollar, nor can we indicate the top dollar that the buyer is willing to pay, unless of course we're indicated in writing by the party to whom the information pertains. And then we cannot discuss competing offers to the buyer if we're in a competing offer situation or personal information of either party. The form also talks about finder's fees. So if, as a client, you were referred to us from another brokerage, perhaps in another area, we would be paying them a referral fee. In most other cases, for mortgage brokers, home inspectors, lawyers, and those types of subject matter experts, we are not paying any kind of finder's fee, but we would have to declare it if we were. After that, the form talks about referral of inquiries. So by signing this contract, you are agreeing to refer any inquiries on your property to the listing brokerage. So that means if someone comes knocking at your door and says, "I've seen the sign on the lawn, can I come and take a look?" The answer would have to be no, you must call the brokerage if you don't have your own realtor. The same goes if it's a friend from work. In any instance like that, by signing this contract, you are agreeing to refer the inquiries to the brokerage. The next paragraph talks about marketing. So when signing the contract, you're giving the sole and exclusive authority to our brokerage to make decisions about marketing, publisher address, and pictures and things that we do to make the property sell. We ask you not to market on your own because sometimes that can backfire. So we make the decisions and we publish it. And if you want to do something with what we've published, bring it to our attention and we'll discuss the best way to do that going forward. There's a warranty clause in the contract that says that the seller warrants that they have the exclusive authority to sell the property. So that means that when you sign the contract, there isn't a third party coming in to lay claim to the equity in the home that would prevent you from being able to sell that home. After that, it talks about indemnification and insurance. So you cannot hold the brokerage responsible for anything other than what's gross negligence or a willful act. Okay, so if a realtor comes to your property and leaves it wide open, well, that's negligence, okay? But if you go away for the weekend and someone breaks into your house because they've been snooping around because there's a sign on the lawn, we can't be responsible for that because it could have happened anyway. It's not our responsibility. Those are just some examples. The next paragraph talks about the Family Law Act. So in Ontario, we have matrimonial homes. And so if your home is a matrimonial home, whether or not your spouse is on the deed, they must sign spousal consent for you to sell the home. They have rights. The next paragraphs talk about verification and use and distribution of information. So by signing the contract, you allow us to distribute the information as we need to make the deal work. We don't send it anywhere it doesn't need to go, but sometimes we might have to send your documents to the lawyer or the bank, for example. On the third page, there is a part that asks if you do or do not wish to be contacted should the agreement expire and not be sold. So it's basically asking you if you do or do not want to be on a calling list, because if you say that you do, then that means that all of the other realtors on the board have the right to come and try and get your business. If you say that you do not and you wish to make your own decisions, then you're protected by the Privacy Act, and if you're hounded by people trying to get your business after signing this portion, there can be repercussions for those people. Successors and assigns. This is a morbid clause that we have on most of our documents. The heirs, executors, administrators, successors, and assigns of the undersigned are bound by the terms herein. So that is the clause that allows the lawyers to try and push forward with deals whenever there is a death, an untimely death, before a deal comes together. If there's a conflict or discrepancy between any schedule that we add to the document and the pre-printed clauses, then the schedule will always supersede the pre-printed clauses. And then there are paragraphs talking about electronic communication and electronic signatures, and that's how we do business in this day and age. After that, it says that the listing brokerage agrees to market the property and on behalf of the seller and represent the seller in obtaining an offer, an agreement of purchase and sale that is satisfactory to them in terms that are satisfactory. And that's where we sign. Then it says that you as the seller, you have read this agreement and you understand it and you realize that you're signing under seal, which makes it a legally binding contract. There is a declaration of insurance, again, for the realtor to declare that they're covered under errors and omissions insurance under the Real Estate Business and Brokers Act, and then an acknowledgement that you have a copy of this document. So if you're signing in person, you're going to get a copy right away because it comes in several copies. And if you're signing electronically, the system will send you a PDF version back to your email immediately after signing.